Yo, what's going on? What's going on, guys? We're going live. What's going on? Who in here? What's going on? I'm gonna hold off a little bit, wait till some people come in here, okay? But what's going on? Shalom. What's going on, guys? We live. We're gonna talk about the appeals process today. We're doing part 3, okay? Showing you guys this is a fight. Y'all gotta be willing to fight this fight, man. What's going on, peoples? Just waiting for some more people getting the inside of this live. Then we're gonna go over this document on the screen. Okay? Got some good information going on. Some good information. Who in here? Who in here? Shalom. I'm just waiting for more people to come in. I was trying to put a notification up, but it wouldn't let me put the notification up early. Who in here? You say I have one comment, but I can't even see the drink. Hold on. This might be a practice. Cause I can't see who up in here. Okay, there we go. I can see y'all now. What's going on, Born Nods? How you feeling, Art? Nah, they normally don't. Bill, what's going on, Billy? How you feeling? What's going on out there, y'all? I already know YouTube not gonna give y'all these notifications, man. There's too much truth going on with it. This app I'm using, I don't really like it because I can't control the screen and see y'all at the same time. Or should I say, see the comments at the same time. Oh, there's about to be some right knowledge, guys. Like I tell you all, you know, this is a fight. Everybody got to be willing to go through this fight, man. Yeah, man. Sometimes we need that break, Bill. You already know. Charles, what's going on, Charles? How you feeling, Art? James, what's going on with you? Glad to see y'all coming out. You know, let's get this right wisdom, this right knowledge, and this right understanding, man. Like I tell you all, man, there's a lot of distractions out here. You know, we had a fraud of law who can't show evidence, like I've been telling y'all, and I'm pretty sure everybody that watch my videos, we all know this already. But his new thing is to fake like he's proposing a threat. You see what I mean? But his threat doesn't mean anything to me, and I keep telling him that. There's no way someone is going to threaten you 2 months straight about coming to see you and never not showed up, not yet. He don't plan on showing up. His whole thing is to keep people distracted from the simple fact of the matter is he can't show evidence. That's it. That's all. And the moment people do apply pressure to him, the first thing he's going to say is, oh, I wasn't threatening him. I didn't do that. I didn't do this. Exactly. So I already know the game he's playing. And because he's, like I said, he's a child in a child's body. You know what I mean? He's like, his mental complex is off. And it's just that simple. But this document I have on the screen, it's got a lot of good information on there, guys, that I need to share with y'all. You know, this is a lot of good information I'm trying to tell you. Yeah, I got you, Charles. I got you. Even though it say vertical 1, but it should be article 1 and article 3. I got you. I understand what you're saying. That automatic spell check be getting you sometimes. Scott, what's going on, Scott? How you feeling, bro? Alright, so as you all can see on the screen, right? Let me get the comments off because I can't see past the comments. Alright, so as you all can see on the screen, this is my arc that we was doing the appeal process with. Alright, so this is his outcome, but we on our way to the Supreme Court as we speak. But now, as you all can see on the screen, this document clearly says what? Not for publication without approval of the appellate division. Okay? This clearly states that what? This opinion shall not constitute precedent or be binding upon any court. Okay? So, when you have other channels such as Fail Flop, he asking me to show precedent, but there's no way I can show precedent because these courts will not allow it to become a precedent. First thing they'll do is simply dismiss the case. Okay? But they will not let this be precedent. You hear me? So that's the main thing we're gonna focus on. I can't go over this entire document, okay? Because this document is not supposed to be publicated. So I'm just gonna go over bits and pieces of it and show y'all exactly what the judge stated at the end. It's ridiculous, guys. But my arc, like I said, we're on our way to the Supreme Court next. If the Supreme Court doesn't answer these questions, then we on our way to where? Federal court. All right? To apply that pressure. But what I tell you guys, man, let's get this right wisdom, this right knowledge, and this right understanding. All right, so y'all, can y'all hear me? Hello? If y'all can hear me, say yeah. Hit that like button too, guys. All right, cool. All right. So hold on. So as you all can see, right? This publication is not made to be shown. All right, and they will not make this a precedent. So let's continue to stroll up. As you all can see, this was argued on February the blank 2020, decided March the blank 2020 with the judges, right? As you all can read it, this was on an appeal. Let's stroll up. It states the defendant, blank blank, appeals from the March blank 2019 family power orders establishing child support for NM and LM, claiming New Jersey courts lack personal jurisdiction over him. So the court said they disagree and they affirm what? The lower court's decision. But that's all fine and well because that's not the only argument that we brought before the appeals court, and the appeals court know that. So as we all can see, though, they're basically stating that they have personal jurisdiction over him, but they never said that they established the child support order. No, they just stating that the personal jurisdiction was established over him. Okay, so now let me stroll up real quick. Like I said, I can't show too much of this document. Let's go down to the final page. Right here, where it states, to the extent we have not specifically addressed any of the defendant's remaining arguments, including his contentions that he is not an individual, obligor, or person, and that the state of New Jersey, under its blank responsibilities, is in fact the true obligor and thus legally obligated to support its children. We deem them without sufficient merit to warrant decisions in a written opinion. So, for those who don't understand that, they basically just said that they're not going to address they're not going to address the remaining arguments that we went over in a written decision, such as him not being an individual, an obligor, or a legal person. Okay, but we know that they must address those issues in court because they claim that he is obligated to support the child. So if they're not going to address is he an obligor or not, then there's no way that they can establish an order against him. And it's just that simple. So the appeals court is simply running from these questions as well. But because the appeal court is running, we taking this argument now to what? The Supreme Court. So if the Supreme Court decide to run from these arguments, then we're going where? We're going to the district family court. District federal court to address these issues. Okay? We simply following the chain of command. But it's crazy that exactly, Christian. Exactly. They don't want the public to know this information. And that's all it is. But like I stated before, it clearly states, to the extent we has not specifically addressed any of the defendant's remaining arguments. So that's just crazy because there's no way that they can go past proving that he is actually an obligor. They must establish him to be an obligor in order for them to what? Claim that he have a duty to support the child. And it's just that simple. So if they feel as though to address that issue is without sufficient merit, then that means that by him not going in these courts and he's going in there challenging jurisdiction, challenging his standing and everything else, and they can't prove him out to be who they claim him to be, then that further proves that what? They do not have the right to come after him or even collect money from him or anything. They cannot make him stand as what? The legal parent. And it's just that simple. And as for you all can see, hold on, let me go right here. And that's the clerk. You see it was signed by the appellate division. But as you all know, it ain't that many people on YouTube that's willing to go over to the appellate side of the court. You know? Only thing they want to do is what? Simply give y'all a few documents, send you on your way. Once you lose, it's over with. None of these cats is not willing to go up to the next level with you all. You know? So like I told you, this is a fight. This is nothing easy or simple that one can just do. You know, you got to be willing and you got to be prepared mentally for this fight. You know, so we all can understand what's going on. Like I stated before in prior videos, you know, there are many guys that have received documents from me who automatically got remedy. But there are other guys that what? Who have to fight a little bit harder or a little bit longer. It all depends on what happened in their situation before they came to me. And it's just that simple. You see what I mean? But we all know, like, even my Mark in this case, he went to court without me in his first hearing. So he came to me specifically just to help him with the appeal. So I got to keep my appeal arguments intact with his arguments that he stated in the family court. Because in the appeals court, you cannot make new arguments. You know, you got to argue the same facts. And it's just that simple. Yeah, but how y'all feeling out there, man? Hit that like button, guys. Don't let nobody come on YouTube and try to distract y'all, man, from this simple truth. You know, everybody need to see proof, man. If these cats ain't showing proof and they ain't showing that they actually putting in work, then like I said, man, don't deal with them. Rule 60B, you talking about federal Rule 60B? We're not in federal court, we're in state court. We dealing with state appeals, not federal appeals. Yeah, Ark, I am Christian. I'm trying to tell you, brother. Like I told y'all, man, you know, a lot of people not gonna come up here and, you know, do what I'm doing. Understand, Charles? Exactly. Facts. Facts. So you gotta be willing to stand in your proper position at all times. I need your proper status at all times, no matter what. Okay? And I already told my op, if he would have came with me from the beginning, this whole thing would have been a totally different outcome because they wouldn't have said some of the things that they are trying to use against him. Like I stated before, they're simply trying to stick to them having jurisdiction. But even though they have jurisdiction as if they claim, then you can have jurisdiction all day long, but you have to prove without a shadow of a doubt that I am the obligor obligated to support the wars of the state. And it's just that simple. And that's not what they're trying to address, because they know once they address that, it puts everything back on the state, who is what? The true obligor. And it's just that simple. Yeah, but I want to show you guys the full document, but the full document, it doesn't say much. They basically just state how he uh showed up to China's jurisdiction. That's all they state, and they basically stating because he actually showed up to China's jurisdiction, that gave them jurisdiction over him. But like I told y'all, he showed up without coming to me first. If he would have came to me first, then he would have been prepared for that argument as well. Yeah, correct. But correct, Bill. But like I tell everybody, if you fighting in your state, then use your state rules of civil procedures and your state codes and everything to address the situation. Because they will throw it out by you quoting federal rules. They will say, nope, that do not apply to us. That applies to federal jurisdiction. Right now, you're bringing your claims into the state. So that's what I want everybody to focus on. Learning their state rules of civil procedures. Because everybody has been, a lot of people have been brainwashed to only think about the state, man. Excuse me, only think about the federal side of this thing. But the federal side is nowhere near the way to go. The federal, only thing they did was implemented the rules that the state must follow. Once the state follow the rules, then the state is enforcing everything. Everything falls against the state. The state handle all family matters. And that's what I want the guys to see. But let's go back up to the top again for those who haven't seen it. It clearly states that they don't want this document to be publicated. It's crazy, right? And they basically stating that this document cannot be used to constitute precedent, which is crazy. But like I stated before, they know, like we know, we already filed our documents back into the Supreme Court. So the Supreme Court already got its certificates of certification and everything else. So we out here fighting, man. Like I tell y'all, there's levels to this fight. You got to be willing to go through it all. There's no quick fixes here, man. Like I tell y'all, that 3-day affidavit, or excuse me, those 3 affidavits, 10-day cures don't work, man. Can't nobody on YouTube come on and say it work. you know. But like I said, everybody want that quick fix. There's no quick fix to fighting these people, man. You got to put blood, sweat, and tears in when going against these people. Ask Bill. Bill, no, ain't that right, Bill? You put blood, sweat, and tears in to get free from out there from this situation. That's exactly what happened, Christian. They did pick the arguments they wanted, but they tried to ignore the rest. Why? Because the other arguments. But even then, they still have to prove those arguments for them to even claim to have jurisdiction over him. They also have to prove those arguments to claim that he's obligated to support the child. Those the situations or the arguments that they do not want to address. Oh, you're welcome, Michael. You're welcome, brother. Shalom too, Nah, see what it is, Christian. You don't, man, yeah, that's true. You want to appeal with your strongest argument, but you want to at least have 3 strong arguments, okay? As we can see, they only picked one argument, which was what? Jurisdiction. But like I stated before, let's say they did have jurisdiction over him. Even if they had jurisdiction over him, they still haven't proved how he is an obligor obligated to support the child. They haven't proved that. What happened was they simply defaulted him into child support. And it's just that simple, you know? Because the second hearing, he wasn't even there on the second hearing. They had a hearing without him because he appealed the first hearing. Once he appealed the first hearing, they automatically scheduled him a hearing that same day. But he didn't go to that hearing. He actually went home. He didn't know about it. So because he went home, they had a hearing without him, so they made a default judgment against him. So now we're challenging the default judgment and everything in the appeals court. Right, exactly. But remember, we have to stick to the arguments that he argued when he was in court. All right, Christian. Like we just can't pick one argument. You gotta pick three strong arguments because as long as you argue them in the lower courts prior to coming to the appeals court, then the appeals court has to address those arguments, basically uh, asking where did the trial court's error or did the trial court's error in ruling against him, making him obligated to support the child without proving that he is in fact an obligor. You see, because the whole ruling, they're trying to say that he's responsible for paying child support, which means he's obligated to, but they can't prove how he's obligated to. They can't even prove if he's an obligor or not. Then it states, what you say, Bill? King, you said your order say voluntary? That's crazy. Born, what's going on, Born? Let me see what you said. Since they are claiming he gave jurisdiction by coming in there and challenging his wickedness. In other words, always challenge jurisdiction before arrival or appear. Yeah, you always got to challenge jurisdiction, but you got to make sure your paperwork beats you there before you go into the court. See, like I told you guys, he went in there without my services first. He just went straight in there, and then after he went to challenge jurisdiction, then he came to me. But everybody know that deal with me. We make sure our documents beat us into the court. King, you said your order is voluntary. Yeah, that's maybe because you went down to the agency and signed. Let me see. Exactly, Bill. Like you stated, the first one was hard, man, but the second one, we made sure the second one was gonna be easy because we stopped that at the beginning, Bill. You Christian stated, even the answer you got, I saw they say they had personal jurisdiction, but they give the reasons they had jurisdiction. Well, what it is they're claiming that simply because he showed up challenging jurisdiction, they have jurisdiction. Some of that is true, because once you make a general appearance, the general appearance do waive jurisdiction. But even if they say they do have jurisdiction over him, they still now have to prove that they have jurisdiction. But after they say, okay, we prove that he made a voluntary or general appearance, we have jurisdiction. Okay, now jurisdiction has been established, but now you have to establish the fact if he's obligated to support the child or not, and that's not what they're trying to address. They're not trying to address his standing as he appeared before the court or as he arrived before the court. Charles said, I'm in an article. Let me see. Keep jumping around. Where's that? I'm in an Article 3 family court with a real judge, not a magistrate. Every time I start, they keep jumping. Every time where you at? Okay, every time I start talking about proof of contract, threatened arrest in the entire courtroom. I keep moving. In the entire court. Hold on. In their entire court. Where we at? Keep jumping around. And the entire courtroom starts dancing. Exactly. Whenever you bring your facts into the court, man, you ought to see a different change. Threatened to lock me up if I didn't sign. Yeah, they did me the same way. King, where was you at? Was you at the agency when they did that, or was you in the court building? I'm pretty sure they just brought you in for a negotiation meeting, and then they threatened you. That's how they did me, man. They brought me in there, then they threatened me. But like I stated before, if it's a negotiation hearing that you was in and not before a court, then simply challenge that document that they forced you to sign. Since 2010, and it was a court order under threat. So it was a court order. Okay, I just read that. My bad. Let me see. But even then, you can challenge that original court order. Okay. Yeah, he can get off. Tell the doc he can get off of child support too, man. Tell him hit those books, study, and that's at Bishop Blueprint. Tell him he can hit those books hard, man. Let him study, get that right wisdom, right knowledge, right understanding. No negotiations, exactly. Yeah. I just read that, King. You said that you was actually in court. So they brought you into the court for the negotiation hearing, but they didn't. But basically, they deceived you. Had you walk in there, you made a general appearance. After you made that general appearance, they moved forward, and then they made you sign that contract or that order. If you didn't sign it, then they was gonna hold you in contempt, or if they was gonna try to default you out into it anyways. How would they prove he is obligated? Only how they can prove he is obligated is they first have to prove that he's an individual, a person, or obligor. That's only how they can prove he's obligated. If they can't prove that on it for the record, then there's no way they can prove he's an obligor or obligated to pay the support of of the minor child. No paternity test, but King, did you sign a DNA? I mean, excuse me, did you take a DNA test? And yes, Christian, you can. You can always go back and challenge a void judgment at any time. At any time, you can always challenge a void judgment. No paternity test either, huh? Hit me up in my email, man. You can do something about that. That's easy. But on the record, did you state out of your mouth that those was your offspring or that was your child? Because the child and offspring means the exact same thing. So did you admit in open court that they were your children or offspring? And that's for King. Remember, it's three ways they can establish paternity. One, if you speak and involuntarily say that you are the child's father, or if you signed a birth certificate, or if you what? Took a DNA test. Okay? Two of the three that you can simply get away by just simply challenging. The third one, which would be speaking it out of your own mouth, they will use that as testimony against yourself. That's why I tell you all, be careful what you say in these courts, because the words you say can and will be used against you in any court. So choose your words wisely. That's what's up, Charles. That's what's up. That's what's up. And that's how it's supposed to be. So, so Ken, you say you never spoke it? You just signed? Do you have that original order? Do you have the original document or the instrument that you signed in court? Sharap the Don, what's going on? Shalom, Mark. You said I never admitted, never signed, and refused DNA, and I'm still on child support. All right, so when you went to court, did you make a general appearance? Did you just show up? And did you claim on it for the record that you was the child's father? And did you rebut the DNA? Excuse me. Did you rebut the affidavit of paternity that was filed into the court, or the affidavit that the mom stated that you were the father? If you need a clear copy, King, go to the court, and the court will give you a clear copy. Yes, sir, James. If you say you're the father, that makes you the obligor, because you stated out of your own mouth. Once you say that out your own mouth, that creates the duty of support. Once you create the duty of support, that means what? The parent-child relationship has been established. Once that has been established, the duty of support is automatic. Email me at yahismagnified@gmail.com, King. So before you even go to court, you should have your documentation beating you guys there. Like my ARC, man, that the one that I'm helping for free. We sent documentation into the court, and we haven't heard back from them yet. And I did that video. I was helping them for free back in what, February? We haven't heard back from them at all. Let's continue. You said I made a special appearance in challenge jurisdiction. I got you. Shalom, Ak. Love the Jews. You're dropping exactly, Ak. You know, we need to get this right wisdom, this right knowledge, and this right understanding, man. All that going to federal court nonsense that these cats doing, and all these fake threats they throwing out there. Come on, man. It's ridiculous, man. Everybody's trying to duck and dodge the simple fact of the matter that no one can show proof, and because they can't show proof, they don't know how to even address the situation that's going on. But they claim that they can help you dealing with child support, and it's just crazy, man. All right, you said your name is Will B. Okay, the subject of the email. All right, cool. Exactly, Slaughter. Yeah, man. It's a good turnout, man. I'm glad to see you brothers in here getting this right wisdom, man. If my ex used my SSN to apply for welfare and or child support, why not start a civil suit for aggravated identity theft? She never took your identity, man. They never did any of that. Remember, only thing she have to do is give your name stating that you are the father. Make a sworn testimony saying that you are the father. Okay? After she do that and she apply for them services, them peoples are on your heels. They already know your social security number and everything once they get your name. That's their property. They know that social security number. You said they kicked you out the courtroom, huh? I mean, it all depends what you said, Sarat. It all depends on what you said and how you went about doing it. And and I already know who services you use, man. You made a video about that. And like I was telling y'all back then, don't go in that way. But a lot of y'all went with the free services, so you can't knock that. Yeah, Robin, you can change that too, man. You said zero back support, zero present support, but they're hitting me for 40 grand on a risk. Can I change that? Yeah, Art, you can change that. You just gotta challenge that original instrument they're using against you to get that 40 grand off you. Okay? If I'm the obligor, is there a way to rebut it? There's a way to rebut it. Like I told you got to get the original order or the original document that they're using against you to hold you as that obligor, okay? Do they keep an archive of what was said in each case, each appearance? Yeah. Most of these cases are recorded. What's up, Ark? What's going on, Constance? How you feeling? Yeah, you should have objected. And remember, I hit you up, Sarap, in your email, in your comment section, telling you had a certain amount of days to file that appeal. You said how child support being closed as settled on your credit, but CSS said you are still in arrears. Yeah, because basically dealing with credit report, as long as you can challenge, anyone can challenge the credit report. That's easy to do, and you can easily get it removed from your credit report. But just because the case say it's closed on the credit report, that just means that they're no longer applying new arrears to your it's basically meaning that they're no longer proceeding after you on your credit report. Basically saying the case is closed, but you still owe this amount of debt. I also bought being closed and said, okay, chilling, happy I made. My man, glad to see you here. Glad to see you here. Exactly, James. 30 days on any appeal. So, Rap, you have to challenge the original order, okay? You have to draft your documents up and everything else to make sure you put everything down, have case law and everything to support your argument. Just don't go in there just saying, I'm not the father, okay? You got to have documentation and everything else, case law, everything to support your argument, like I did for my ARC. And they clearly stated that they're not going to give him a written decision, okay? Because they know if they write it out, what he said, and they had to write an answer for it, they couldn't. And like I know they couldn't. And if they did try to, then what they write would eventually expose the fraud. Let me see if I can try to put up my email. I'll put it at the end of the video. It's yarsmagnified@gmail.com. Okay? And it's also in the description box. You can click in the description box. It should be right in there. Y'all got any more questions? So you want to study Sarap? Make sure you study your state court cases, okay? Case law to support your argument. Because like it states right here for all to see, it states, to the extent we have not specifically addressed any of the defendant's remaining arguments, right, including his contentions. Hold on, I can't even see it because the words keep popping up. His contentions that he is not an individual, obligor, or person, right? Then it states, and that the state of New Jersey is under its blank responsibility is. Hold on, I can't. Let me remove these comments because they keep popping up, blocking all the words. Hold on, let me get up out of here. Is in fact the true obligor and thus legally obligated to support its children. We deem them without sufficient merit to warrant a written decision or written opinion. Okay? So again, they don't want to write this truth out because they know if they was to answer these questions and these remaining arguments that we put on the record, it's going to expose everything. So since the appeal court don't want to address it, but they still want him to be an obligor, that's what I'm saying. I don't understand. How can they not address whether he's an individual, an obligor, or a person? They're using these terms alone to bind him to pay support. They're saying that as an individual, he is obligated to pay child support. In order for him to be obligated, they use the term obligor, which means one to be obligated. And it's crazy. You can get the original order. If the courts are closed, then you may have to wait until they open. Okay. Oh, you can also hit the agency. The agency has copies of all your original documents. Believe me, they have copies, and they can send you copies of everything that they have using to hold you as this obligor. Courts don't answer when they see. Courts don't answer when they see fit, but then hold you in contempt when they don't answer the fraudsters. Right, exactly. The wolf. Straight fraudsters. Blueprint said, how do you challenge the validity of a DNA? Email me, Op. Email me. Hakeem the Dream said, I got a letter trying to take my taxes. No signature on it. And the amount in the box on the paper. What should I say in a conditional acceptance? I can't tell you what to say, Op. If I tell you what they say, they can say, I'm practicing law. So I can't tell you exactly what to say. But simply challenge everything that they're claiming on that document. File a rebuttal for everything that they're saying. So address the document they rely on to attempt to bind you to their allegations. Exactly, Alex. Exactly. What Florida agency? God, keep popping up. Do not want you to come. It's Florida and you have an attorney. Exactly. Sweet daddy. Ask for the original document. Sign a family law mandatory discovery code for your state. Exactly, Charles. But they, like I stated, once you ask for those original documents, they will give them to you. Okay? You need those original documents to find out what has taken place in your case or in the case that they're bringing against you. What if an actual judge has not signed any of my documents? So your documents does not have a signature on it at all, Robert? Not one signature on it? Somebody had to sign that document. And then you got to find out who signed it and was this an administrative order or a court order. Okay? You have two different orders. An administrative order most likely was an order that, they called you down to the agency for a negotiation hearing. You went in there, you signed it voluntarily. That's an administrative order. A court order is when you go before a magistrate judge, and that magistrate judge make a ruling in against you. Okay? Only a hearing officer. What hearing officer? Was this a hearing officer in the court building, or was this a hearing officer at the 4D agency? Yeah, minute order can be an order, Alex, but you can also challenge the minute order. Like I said, whatever document they're using against you guys to try to hold you all accountable for being the obligor, you must challenge those documents. Mine was signed in the signature box. God, box of the judge. So who signed it? Who signed it in the signature box? I was thinking about asking them if they can prove that they obtained my SSN lawfully, because they had my SSN on the letter too. Good idea and bad idea to use that one. Yeah, because remember, I came the social security number. They can search that. Only thing they need is your child's mom going down there stating that you are the father. That's all they need, and that's all they move on. They move off the presumption. And then they establish that presumption to be facts once you go to court and say that you are, or they look at the birth certificate, if you didn't rebut that, or if you don't rebut that prior to going to court, and if they look at the DNA documentation that they have on file for you, if you don't rebut that, and you just go straight into the court. If you go straight into the court without your documents in hand and file stamped before you even get there, then they will proceed forward and try to hold you at this thing called an obligor. So you said a child support rep signed what? What is it that she signed? We for y'all? James Jameson says, if I got a new job and the BM has not updated her place of employment, do I still need to update my status? Being that we are not going before the magistrate. No, you don't have to do anything. Like I stated, they need you to go in there and voluntarily snitch on yourself. You know what I mean? Majority of us guys that was dealing with child support, or the ones who are still dealing with child support, we once went in there and we told on ourselves. That's exactly how they got us to do the things that they're doing. Like I told y'all, even in my situation, I went down there, I went to challenge it, but this before I knew anything. So I went to challenge it, and the lady told me, if I don't sign it before I, they'll arrest me before I get to the front door. So I was like, man, then I just went back and signed it. But if I knew what I knew now, I would have most definitely walked away and left her right there standing, But hey, we live and we learn. How else you gonna get this remedy? You gotta live and learn. You gotta go through it. She on record claiming not to be a judge. Okay, so you must got an administrative order. Did you sign that, Robert? I didn't sign anything, and they still railroading me. Okay, so is there we for y'all? Is there is there a default judgment in against you? You said no default judgment in against you. Okay, so again, if she's not a judge and you know she's not a judge, then do what? Like I stated, challenge that original order. And all right, so Rob, we got the original order. Okay, so now read that original order. Pay close attention to what it's stating. Any presumptions on that document, you need to rebut each and every one of them. So if you're fighting for custody, how can that bind you up in support? Because if you're fighting for custody, you're going in there voluntarily saying that the child is yours. And once you say the child is yours, that automatically gives them what? That gives them the right to give you the duty of support. Why? Because you claim that the child is yours. So if you don't get full custody, or if you don't get full legal and full joint custody, or if you don't get joint full legal and joint custody, which they don't like to give men because they give you all those things, then that means there will be no support. So what they'll try to do is do like a 75-25, or you only get on the weekends, or the child only on the weekend and stuff like that. That's to keep the enforcement payments going. Sweet Daddy, hit me up in my email. godsmagnified@gmail.com. The link is in the description box. In your case, you can title it a motion to vacate or a motion to terminate. Okay? And that's for you, Sarab Don. Yeah, so I always tell man, you know, if you want to fight for custody, go ahead. But I don't recommend it because no one can have you the right on when to see your seed and when not to see your seed, you know. And if you go to the court and you petition the court to ask them for anything, that means you giving the court jurisdiction over you automatically. So once you go to court, right? So if you on offense and you petition the court, okay, don't go to these courts saying you're not the name, this, that, and the other. No, when that's the straw man argument is made for defense and defense only. If you're on offense, you're not gonna go to court saying you're not the name, you're not the straw man, and this court does not have jurisdiction. Do not do that, okay? Because the moment you do that, the judge gonna say, okay, well, cool. Since you're not the name and this court don't have jurisdiction, then we have to dismiss the case because we can't hear this case because out of your own mouth you said that this court doesn't have jurisdiction and you're not the name. So until the name do appear, then this case will be dismissed. So you all got to understand how to go on offense when you're on offense and when you're on defense, okay? Never took a DNA test, never spoke to a judge, was default in my absence, been 6 years, cannot challenge BM for stealing my SSM info, and nobody has first-hand knowledge, i.e. an attorney. So the whole thing is this: if you didn't take a DNA test, right, and you never spoke to a judge, but they feel the default judgment against you, Kim, then you have to challenge that what? You have to challenge that default judgment. And it's just that simple, Kim. That's all you need to do. Challenge that default judgment, man. You know, you can simply file a motion to vacate to challenge that default judgment. The statutory law prior to private law. Now, private law is private. You know, you always leave private in the private. Yes, sir, Akim. Yes, sir. But Robert, if you're dealing with the private, you got to make sure you stick with the private. Don't try to put them together. Okay? Private is private. It's exactly what it means. Private. You can't mix the public with the private. Keep them separate at all times. Because once you do, you automatically become public. Before y'all have done all that filing and they won't hear it. She ignores you and kick you out. And they block me every time I try to access the court. It all depends on what for y'all. It all depends on what you're filing into the court and who's assisting you while you're filing your information into the court. And you know, because a lot, like I said, man, a lot of people are filing. You know, they're using other people's services who on YouTube who claim to help, but the documents are all frivolous documents. So they don't give you your day in court. All right, James. Yeah, I mean, judges and magistrates, they basically one and the same, to be honest with you, man. You know, especially dealing with these Article 3 courts. All right, basically, the magistrates receive their appointments from the judge, okay, and that the judge have authority to appoint the magistrate because the legislator gave them the right to do so, and the United States Constitution gave them the right to do so. James Carr, what's going on? Ark, how you feeling, brother? Exactly, Robert. Yeah, your case is a private matter. But she went down, but not because she's not paying for public assistance. She still has the right to go down there and apply for services. You see, so she can't they can't deny her those services. So because she went down there and applied for services, and basically they probably stand that you and her don't live in the same house or nothing like that, so you have a duty to support or pay your part towards the child. So they're gonna try to use that against you until you challenge that original order. Kim the Dream said, "Thanks, bro. You really helped me a lot with your free info. I'll be hitting you up soon for donation, even if I don't get your assistance gift." Thanks, Ark. I really appreciate that. No, the magistrates are not judges, but magistrates are acting as judges. Okay, a magistrate can take testimonies, and if they take testimonies, then they can send their testimonies and give advice on what they basically give their opinion on what they believe the court should do. The judge will read over the advice of the magistrate, and then the judge can sign right behind the magistrate, enforcing the magistrate's opinion. Exactly, Billy Rowe. A magistrate do give and take orders. But like I stated before, their powers also come from the legislator as well once the legislature appoint judges to appoint magistrates. Under the United States Constitution. Man, there's 86 people up in here. That's what's up, man. That's what's up. Hit that like button, y'all. Exactly, Charles. Exactly. Magistrates can give recommendations. That's what it is. Once they get their recommendation, then they turn their recommendations over to the judge, and the judge will sign off on it. In their time frame, the challenge orders, even after the 30-day time for rebuild or final order. You can always challenge. You can challenge any void order at any time. An order is void. You can challenge that void order at any time. So now you must get that original order that they're using against you to rebut the presumptions to make that order void. And that's that for you, DPG. Yeah, but it's crazy, man. Like a lot of stuff going on, guys. It's crazy. But like I was telling you all, it's certain situations that they will not address. Like like I was telling y'all, man. Even the dude Phil Flop, he was trying to say that the stuff that I do don't work because I can't show him president. But I'm telling him, without a shadow of a doubt, they will not let you post. They will not use your arguments as president. Why? Because your argument can basically bring down the whole system, and that's what they don't want. Like I stated, guys, it stay right here. Hold on, let me get up out of here. Let me close that down real quick. Like it states right here, this opinion shall not constitute precedent or be binding upon any court. You see, and they put that in quotations on purpose. Okay, and they also said what? This is not for what? Publication without the approval of the appellate division. You see? That's why I blanked out everything. Nobody else on YouTube gonna show y'all that, man. A lot of people, like I stated before, man, they're not putting in that time. They're not putting in blood, sweat, and tears. They're not willing to go to the next level, no matter what it takes to get this remedy. You know? My Ark went in the court. He stood his ground though, man. He did real good. So the only thing they can get him with is jurisdiction. That's the only thing they wanted to talk about or they tried to address. They don't want to address the remaining issues, even though they call him an obligor. They don't want to address the issue on how exactly is he an obligor. You just can't call me something and not explain how I am that. You can't say, oh, well, you're obligor and you're obligated to support this child. The first thing you're going to say is, well, how am I an obligor? And what makes me obligated to support this child? You see? If they can't tell you how you're an obligor and what gives you the right to support the child, then there's nothing else to talk about. If they try to bring the birth certificate up or a DNA test, all that can be rebutted. You see? You just have to be willing to rebut all the presumptions on it for the record. This is what nobody is telling you guys, man. Everybody keeps saying, it's a contract, it's a contract. I was saying that years ago. You see what I mean? I was saying all that years ago. It's a contract, it's a contract. You see? But 3 years ago, before all these other cats were saying it's a contract. They got it from me. When I first came on YouTube, I said what? Everything in America runs on a continuous series of contracts. Okay? But they're not understanding. You have verbal contracts, you have written contracts, you have affidavits or sworn affidavits on the record that men not even addressing. But when they get to court, they wonder how they end up in this situation. Because you just had a whole sworn affidavit against you, and the unrebutted affidavit does what, guys? Stands as truth. And they don't even know that. So first thing they do is go to court, say, I take care of my child, or I'm not the father, or I'm not the name. But before you can even say all that, you must rebut the presumptions that's already placed on the record against you. And it's just that simple. It's just that simple, guys. Let me finish drawing all the way up. Yeah, but anybody got any more questions out there before I get up off of here? I'm getting hungry, man. About time to get something to eat. And like I said, guys, don't let nobody distract y'all with these fake internet threats, man. Because I know, nobody's going to threaten you for 2 months straight talking about they're going to come and see you, but they never do. So the only thing they're doing is trying to distract the people from the truth. And the truth is what? Their services don't work. Okay, so don't let nobody try to convince y'all that they do. Okay, like I said, if they can't show evidence of their own case and they can't show evidence of anybody else they're helping getting results, then don't follow them, man. Okay? Because the moment somebody do start to apply pressure, the first thing they're going to say is, well, I never threatened you. I never threatened you. Yeah, exactly. Of course you're going to say that now. But we all know, man. Stop trying to, just go out to all them frosters out there, man. Stop trying to change the subject. Stick to the topic at hand and show that proof. It's just that simple. If you show proof, you would have shut me up a long time ago. But obviously you can't show proof, and that's why you're mad. Yep. But like I said, guys, before I go, anybody else got any more, anything else to ask? Any more questions before I go? Alright, so if no more questions, man, you all be blessed. That's all I'm going to do for today. Now that I got my live stream up and everything set, I can do this more often. So I'll be coming on live a lot more often, man, to show y'all a lot more other things as well. Things that I wouldn't just show you all without having this proof on the screen. Okay? So you all be blessed, man. Like, share, and subscribe again.